Alex. Hi, everyone. I'm Michael Swistera. I'm the co-chair of the Animals and Agriculture Subcommittee, and I'm just going to quickly introduce our speaker for today. Today's Lunch and Learn is on the politics of plant-based state and federal labeling laws, context, significance, and future implications. Our speaker is Amanda Howell. Amanda is a managing attorney at the Animal Legal Defense Fund in the Civil Litigation Program. Prior to joining ALDF, Amanda worked as Assistant Director of Litigation at the Center for Science and the Public Interest, and she headed up the food law practice at the Stanley Law Group. Over her more than 5 years at ALDF, Amanda has applied her experience with strategic impact litigation to advocate for a food system that better serves animals, the environment, and public health. This includes extensive work at combating humane washing, as well as protecting plant-based companies from unconstitutional attacks by the meat and dairy industry. Without further ado, I will turn it over to Amanda.
Thanks so much, Michael. And thanks to you all for having me. Bear with me for just a second while I get this PowerPoint going. Can you all see that? And I don't see you right now, so an audio would be great.
Yes.
Okay, perfect. Thanks so much. Okay, so today I understand the time I've got is only half an hour, so I really wanted to specifically focus on like one part of the work that I do. As Michael said, we at ALDF protect our lives and advance the interests of animals through the legal system. A lot of my work is, like Michael said, humane washing class actions, consumer protection class actions. The other side of things, it's kind of on the flip side. Another way that we support animals and protect their lives is by supporting plant-based producers. Because it's not a huge leap to think that if plant-based producers are hamstrung or if they're supported and people have options when it comes to the protein on their plate, that might mean a decreased demand for animal products, which would mean hopefully fewer animals that are killed to be used for food. And kind of in an overarching way, I think that the path between animal law and food litigation, it's a common sense one. It's a super quick path. So hopefully this is relevant to you all's interest and work. I think that I can almost skip this slide because it's so common sense at this point in terms of, yeah, plant-based has grown a lot. I've been vegan for, I don't know, 15 years or so. I've been vegetarian almost my whole life, and it used to be really hard, and now it's like pretty darn easy. We see these products on shelves. I think I'm kind of preaching to the choir when I point out with all these like very fun animations that animal or plant-based products they're trying to distinguish themselves from animal-based and slaughter-based products. It's a feature, not a glitch. They might be shelved next to meat products, but I think that they're trying to serve areas of the market that are seeking alternatives to meat products, whether that's for their own health or for the environment or out of concern for animals. Because of all this, and because companies know that that's their market, either someone who's avoiding meat just temporarily or for that meal like flexitarians or for vegans, they're really highlighting, they're doing a lot to highlight the fact that they are plant-based or vegan. And this goes for both plant-based dairy and plant-based meat products. So I'm just, all of these little arrows just show all of the ways that they clarify that they are made from plants and not from animals. So I would say that it's like pretty common sense that consumers are not misled. And some courts have even more so on the plant-based dairy side, because I think it just strains credulity too much. So no consumer protection class action lawyer has taken a class action up for plant-based meat products confusing the reasonable consumer. But there have been some cases for these types of products, the plant-based milk category. That is, I think, more than 10%, it has to be now because I haven't checked for a couple of years, but more than 10% of liquid milk category is plant-based. So, someone said, hey, maybe I can get some federal court to say that almond milk is confusing consumers into thinking that it's, milk from cows, which is crazy. And the Northern District of California, the Central District of California, and eventually the Ninth Circuit all said, no, that's crazy. Reasonable consumers are not misled took it one step further and said, not only are they not misled or likely to be misled, they're also not likely to be misled into thinking that these products are imitation milk products. And that's important for a couple of reasons I'll get into later, that the Ninth Circuit determines, in this case called Painter v. Blue Diamonds, that consumers, because they know that the underlying ingredient, like almonds or soy or whatever, is a different product than milk, that they don't think that they're nutritionally equivalent. So as we see through these labels, people use things like milk or sausage or whatever with qualifying language like veggie or vegan or plant-based or non-dairy or soy or what have you. Sometimes I think we've all heard silly questions like, well, why do they need to use, like, why do they need to call it meat if it's not meat? Well, that's really an easy answer. The most effective and simple and truthful way to tell consumers what to expect from a product might be using a term that they are familiar with, like milk or sausage. None of these products are ever calling it just milk or sausage. They're calling it obviously like veggie sausage or plant-based sausage and soy milk. That said, what would removing and not using terms like milk or sausage do? Well, it would likely decrease sales because of increased consumer confusion. If I were to call something like a cultured soy spread, I'm not sure that the average consumer would know how to use it, or like would even, is that something that you put on toast? Is that something you cook with? Like, but vegan butter, that's something that they would know. So it doesn't require a large leap to understand this is an important way for plant-based products to sell their products and convey the organoleptic properties of their products to consumers. And so because of that, I don't think it requires a large leap why the dairy and meat industry has suddenly taken up this like semantic argument and become the semantics police when it comes to use of these terms, these non-proprietary terms. We know that, I think, we're all maybe lawyers here. There are a lot of applicable labeling laws and laws that govern the labels and packaging and marketing for plant-based products. Under FDA, which is what plant-based products are governed by, there's the FDCA, there's the FTCA, the FTC Act, and there's obviously the Memorandum of Understanding between FDA and FTC saying FTC covers marketing and FDA covers labels and labeling. There's also state UDAP, unfair and deceptive acts and practices laws that apply to these plant-based producers. All of these, this onion layer of like federal and state laws, all basically boil down to they can't do anything that's false or misleading in any particular. You obviously can't, like, commercial speech is protected only to the extent that it's not inherently misleading. So, there are like a lot of layers already protecting consumers and already prohibiting plant-based producers, just like any food producer, from engaging in conduct that would serve to confuse consumers. These laws have been on the books for forever. And it feels like plant-based products have also been on the shelves for forever, like decades, like 50 plus years at least. And all of that time, you look at the FDA enforcement history, you look at consumer protection class actions filed, and you see basically a dearth of these types of enforcement actions or class actions against plant-based because, again, historically, no one's been ever confused. So what's changed recently? And I think that was kind of the point of one of my first slides, which is the only thing that's changed recently is not the labels or labeling, it's the growth of plant-based. They have become a lot more popular, and now suddenly they present kind of a market competition to animal-based products in a way that they didn't necessarily used to. So I mentioned earlier the California federal cases that went up on the almond milk and I think soy milk. So just in case anyone's curious, the names of those cases are Gitson v. Trader Joe's, Ng v. White Wave, and Painter v. Blue Diamonds. I'm a dork and I live and breathe this stuff. So if anyone's actually interested in like getting those opinions, or if there are any questions I should have said this at the beginning. I'm happy to send all of these marketing material or any of these legal materials to anyone that wants them. So to get into like the nitty gritty here of what's going on, I kind of have to give a little bit of a background on FDA law, and I apologize in advance for this. So way back in the day, like 1938, I think, FDA decided that one way that they're going to prevent consumer confusion and do their job was to create recipes for products. Basically, they were concerned that about like fillers and not good quality things being added to products to like make them seem like quality, and basically like just like consumer fraud was happening. People were adding like a lot of water to milk and things like that. So FDA said the easiest way to deal with this is to create recipes, so that saying that something has to have a certain set of ingredients or have to be produced in a certain way. Milk has or ice cream has to have this percentage milk, this percentage cream from milk, and fat from milk, and blah blah blah. I think FDA pretty quickly decided that that was going to be a Herculean, impossible task to create recipes for all of the products that are going to be on the market, and there are hundreds of thousands of products on grocery store shelves. And it would be completely impractical to create these things called standards of identity of these recipes for every single product or every single type of product. I think the standard of identity for peanut butter took over 10 years to promulgate. They had to go through formal notice and rulemaking and all of that. It took 10 years for peanut butter. So FDA said, this is impossible. And what's easier? Let's create these things called statements of identity. And that means that companies, food companies, get to decide, the name of their product, the common or usual name of their product. That has to also be on the principal display panel. But as long as it truthfully conveys the nature and contents of the products to consumers, then we don't need to create that recipe. So when you look at, a box of Cheerios, it might say like Cheerios really big, and then like kind of you'll see something on there saying like, I don't know, like oats cereal product, or if you look at fruit snacks, the statement of identity, we fruit snacks, which is fruit snacks, statement of identity, fruit snacks. It's supposed to be on according to FDA regulations, every product is supposed to either have their standard of identity or statement of identity on the principal display panel. So just next time you're at the grocery store, take a look. It's kind of interesting, and I would say that consumers don't actually get a lot of information from the statements of identity. That said, for plant-based producers, things like soy milk or veggie sausage would be those statements of identity. So they're actually kind of important for plant-based producers. So these names of products are at issue, right? I guess I should have said that there are several constitutional cases that ALDF is involved in right now. And they're all kind of about different state actions trying to prevent plant-based producers from calling themselves, from using certain names, meat and dairy terminology in their common or usual names in their statements of identity. And these state laws are being passed and have been passed, saying that the reason that we can, have this speech restriction is because consumers are confused. It's inherently misleading speech, and a substantial government interest is in protecting consumers and preventing confusion. So, that kind of makes us ask, are consumers confused? Which I think it's a common sense thing. The only empirical evidence that's out there supports the fact that consumers, of course, are not confused. This is one survey that we came across and before we were at the motion to dismiss stage in our case defending Miyoko's vegan butter products. And these two professors at University of Oklahoma did some very rigorous research, found that consumers are not confused between the differences between animal and non-animal source dairy products labeled with milk. In fact, they were more confused within the category of animal-based milk. Like consumers didn't know the difference between like 1% or 2% milk and skim milk and things like that. They had a harder time identifying like animal-based dairy products within that category than between animal-based dairy products and plant-based dairy products. We, in the course of litigation, the Phelpses did another survey for us to support our client Miyoko's, and we tested those exact labels. And again, it's kind of what you would expect, same type of conclusions after rigorous empirical research, saying consumers are not confused. They will be no more confused about plant-based food labels than they are about animal-based food labels, maybe even less so. And it sounds a little pithy, but again, common sense here. People are fairly good at understanding those simple adjective labels. Okay, so there was another survey also, pretty rigorous. It involved plant-based meat products and plant-based dairy products. And this one kind of two things. It confirmed with Phelps's research, obviously, that consumers are not confused by these like qualifying term plus, meat or dairy term, adjective plus, meat, dairy. It took it one step further and it actually found that when those terms like milk or sausage were removed from plant-based products like soy milk, it actually increased consumer confusion. It's kind of like that like cultured soy spread thing that I mentioned earlier. Consumers actually don't know what that product is. And so then kind of we have to ask ourselves, so if consumers understand these products as they are and as they've been labeled for decades, and if removing the animal term or the non-proprietary dairy or meat term increases confusion, like and given that these state laws are being passed in very animal agriculture heavy states and have been supported by animal agribusiness, like I don't think it takes like a huge leap to realize the reason that they're trying to pass these laws and why they're, unfortunately succeeding in passing these laws are because they want to stoke and cause consumer confusion where there was not any before, because it would be incredibly expensive to change labels and marketing for products, because these plant-based producers would lose market share if consumers didn't know what their products were and they weren't able to market them in a way that, concisely and accurately conveyed those organoleptic properties so that consumers could, know what to expect when buying these products. And also, I think this is kind of gets to our dormant commerce clause theory that they're creating a patchwork of laws in an area of like currently nationwide regulation. The FDCA and applies at the federal level. States have adopted generally the FDCA into their state codes. What these laws would do then is to make it impossible for plant-based producers to comply with the laws across the country. They would, have to have different labels, and of course, this is impossible for different states, and not have marketing cross into those states. So I've alluded to this a little bit, but this is kind of a list of kind of a summary of what animal agribusiness lobbyists have been pushing for, different ways that they've pushed. This is at, both the state and federal level. About a decade ago, like lobbyists like the National Milk Producers Federation, NMFP, see that, had started harassing FDA. The United States Cattlemen's Association started harassing and sending citizen petitions to USDA, which is actually barking up the wrong tree if they're concerned about plant-based, saying that FDA should enforce their standards of identity against plant-based, that they should, say plant-based producers can't use terms like milk or butter, even with qualifying language. The US Cattlemen's Association said, USDA should promulgate standards of identity that would prohibit plant-based products from using terms like beef or, meat. They didn't get any traction at the federal level. FDA mostly just ignored that. They had a couple, like 2, 3, 4 requests for public comment. And actually there is something coming down the pike on FDA land that I'll get to at the end. But USDA just ignored the Cattlemen's Association petition for a really long time and then eventually said, we don't have jurisdiction over plant-based, so we can't do what you're asking us to do. These are just some of the letters to FDA. When these lobbyists realized they weren't getting traction at the federal level, they then turned to the state level where they got a lot more success. Less sophisticated legislators, ones that are a little bit feel maybe more beholden to their animal agribusiness interests in those farmers in places like Missouri and Arkansas and Louisiana and Oklahoma, Texas, things like that. So the first law that was passed was in Missouri. It bans anything that any plant-based producer cannot misrepresent their product as meat. That's like very vague and broad language. Arkansas followed. It had a laundry list of things, but kind of similar, only it said you couldn't represent a product as meat. And you can't use, this is why we won on the due process clause, void for vagueness here, this phrase, utilizing a term that is the same or similar to a term that has been used or defined historically in reference to a specific agricultural product. Like what does that even mean? And like, who can that apply to? And how can you comply with that? And if you're a plant-based producer trying to, you're a small company, you're trying to sell your products in a state, and the Missouri law, that's a criminal law. So you could be thrown in jail for a year per violation. And there are, huge civil penalties in Arkansas. It's like, I think 1,000 or 500 per violation per day. So these are actually really scary laws. We might see this type of language and laugh and say it's ridiculous. But if you're a plant-based producer, this has the potential to really damage your business or make it impossible to do business. This is Louisiana law that we challenged, and they're all kind of similar. As you can see, they're like just flat out bans on speech. The Oklahoma law that we're challenging is a little bit different. It's more of a required speech disclosure requirement than a ban on speech. It's basically saying you have to, if you use these terms, meat or dairy terms, you have to also convey that the product is plant-based alongside whatever meat or dairy term whenever it's used and in a type that is uniform in size and prominence, the name of the product. That's problematic for other reasons. Not only because it runs afoul of like preemption issues with the Federal Food, Drug, and Cosmetic Act, but also because PDPs, principal display panels, that's really valuable real estate. And plant-based producers, I think, do a very good job of conveying that they're plant-based, but they have to be able to do that in a way that is like flexible and allows for change, allows for different graphics, things like that. So when you have really prescriptive requirements like this, especially if there are a patchwork of requirements, then it becomes impossible to do business, which is why we have a dormant commerce clause claim in that case. Sorry, I'm talking really fast because I'm cognizant of a lot of content in a short amount of time, but if anyone has any questions as I'm going through this, just scream out because I can't see anyone because of this PowerPoint. So just feel free to interrupt me. Another issue that we had was with the California Department of Food and Agriculture. They sent an enforcement letter to Miyoko's Kitchen back in December 2019, basically saying she had to remove all of these things like 100% cruelty and animal free. She couldn't say her mission phrase, revolutionizing dairy with plants. My favorite and the most ridiculous one was, I think they said that there was a picture on her website that had a woman hugging a cow at her sanctuary. And they said she had to remove that image of a woman hugging a cow because it was something like, it was an activity associated with like dairy and agriculture. And it's like, well, I don't think anyone's hugging dairy cows. And also this is a cow rescued from dairy industry. But, and most importantly, I guess, is they said that her cultured vegan plant butter product couldn't use the term butter because that was running afoul of FDA's standard of identity for butter. So we challenged that. Oh, and just to give again, I said this is kind of common sense, but the substantial government interest when you're bringing a First Amendment cause of action, it has to be an allowable thing. It can't be protecting one industry by attacking another. So everyone's saying this is about, when we bring these challenges, they say, oh, it's about consumer confusion, because that is a substantial government interest. It's one that would meet the Central Hudson test. It's not a government interest can withstand scrutiny, intermediate scrutiny, especially what happens in the legislative history, which is what you're seeing here. Everyone's basically, before they get a lawsuit handed to them, everyone's very clear in these hearings, in these legislative hearings, that the goal of these laws are to protect our cattlemen, our product. We're trying to protect the agricultural producers in our state. They, look at these quotes. They're incredibly helpful to showing discriminatory intent. I'm always willing to help our beef producers. Like, you're not trying to help consumers. There's no consumer confusion. You're trying to hurt plant-based because they represent competition to your beef producers. And sorry about all the fun uh, transitions here. I just went a little crazy because these things are as ridiculous as they are. I think it's kind of fun to see them, admit the truth, at least in one context. So here are the cases that ALDF has led and is leading on this front. You'll see Missouri, Arkansas, Louisiana, Oklahoma, and then the Miyoko's Kitchen, that was an enforcement action. So it was an as applied challenge as opposed to a facial challenge on First Amendment grounds. So like I said, we're bringing First Amendment causes of action in every single one of these cases, except the Oklahoma case, because it's a speech disclosure as opposed to a speech ban. So there are 4 prongs in Central Hudson. As long as the speech at issue, commercial speech, is truthful and non-misleading, then you ask, is there a substantial government interest? We're happy to stipulate that protecting consumers is a substantial government interest. I think we do a little bit of coloring to the judge saying that that's not actually the interest at play here. We don't have to fight that too much, because the 3rd and 4th prongs of Central Hudson is really where these laws fall down, because the burden is on the state, because it's intermediate scrutiny, to show that these, pretty broad sweeping and aggressive bans on commercial speech directly and materially advance the interest of protecting consumers or curing consumer confusion. Because there is no consumer confusion, it's impossible for them to show that these laws directly and materially advance any consumer any consumer protection interest that the state has. They also have to show that the restriction, the ban on speech, isn't any more extensive than necessary to achieve the goal of preventing consumer confusion. When you have bans on speech, and where, just saying, hey, if you add the word, like a qualifying term, then we're good here. That's the speech disclosure kind of thing. That's a much less aggressive and prescriptive way to affect First Amendment interests. So there are a lot of different ways that the state could, if this consumer confusion actually existed, it could prevent that in less restrictive ways to commercial speech. So it's a pretty strong First Amendment claim. In addition to the First Amendment, we are adding in due process void for vagueness, because a lot of these laws are terribly drafted, terribly written. It's impossible for the ordinary person, a person of ordinary intelligence, to know how to comply, know whether their conduct is running afoul. Things like utilizing a term that's been defined historically, like, okay, like that's, if you are faced with being thrown in jail or millions of dollars of fines, like, you better know how you can comply with that law. And none of these laws actually meet that bar. For the Oklahoma case, we have a preemption argument that I mentioned, because it does run afoul of the Federal Food, Drug, and Cosmetic Act, which has kind of a laundry list in its express preemption section. And it's like 12 things that, states normally can do things like different from or addition to FDA requirements, except when it comes to this like laundry list of things. And thankfully for us, a lot of that governs the principal display panel, that like front panel. And of course, the name of the product is something that FDA requires to be on that front panel, which means that anything requiring anything in addition to or different from FDA requirements is going to violate the Supremacy Clause, which is Oklahoma's problem. As I mentioned, the Dormant Commerce Clause, we have a couple of different angles on that, both pike balancing and discriminatory intent and effect. A lot of these things would be governing conduct that's also wholly extraterritorial, like when they ban marketing representations. So even if a plant-based producer could avoid the state, they would still be violating the state law just by merit of having a website or having social media where it shows the PDPs and their marketing, the names of their products that use meat or dairy terminology. So I know I only have like a couple more minutes. But just to tell you where we are now in these cases, we have won our motion for summary judgment in Louisiana. It's currently up on appeal to the Fifth Circuit. I'll be arguing that early next month, actually. But we got really good language. Basically, an excellent opinion from Judge Jackson saying that, yes, this impermissibly regulates commercial speech. The state hasn't met its burden to show that those last two factors of Central Hudson, they haven't actually put any evidence in the record at all, either showing that there is consumer confusion or that the law is necessary and no more extensive than necessary in order to prevent consumer confusion. On the flip side, we have those studies and that evidence. So even though that the burden's not ours, it doesn't hurt to kind of come out swinging on that. So we also have, we won in Arkansas on our motion for summary judgment. Well, actually, it was a motion for preliminary injunction that we asked the court to make into a final determination on the merit. That one, the only disappointing thing is the court granted relief on a as applied basis to tofurkey as opposed to facially. There are questions why we didn't appeal that. I'm happy to talk about that kind of offline. But again, really good language, saying my favorite is, the state appears to believe the simple use of the word burger, ham, or sausage leaves the typical consumer confused, but such a position requires the assumption that a reasonable consumer will disregard all other words found on the label, which of course they don't. So I think that these judges are kind of understanding that this is like, these laws are just protectionist laws, with the guise of consumer confusion, kind of as a veneer of legitimacy that, doesn't actually bear out. We were also successful in our case defending Miyoko's against CDFA. So really good language from Judge Seaborg in the Northern District of California. I really love that he said that, the fact that you're citing a standard of identity for butter that's, like, I don't know, almost 100 years old. And, actually this historical context makes it a worse argument because language evolves and to hold otherwise defies common sense. And as long as we can show that consumers in the here and now are not confused, it's crazy to say that someone couldn't call something vegan butter. They know exactly what they're getting. And Judge Seaborg said that Miyoko's use of the word butter is constitutionally protected. All of those things like, lactose-free, cruelty-free, revolutions and dairying with plants, that's all protected speech, and she can continue engaging in that. The one kind of, I wouldn't even call it a loss there, is on the hormone-free. Because plants contain endogenous hormones, he said that was not actually true, so that it doesn't meet that inherently misleading first prong of Central Hudson. But Miyoko could just add something like animal hormone free or cow hormone free and then continue engaging in that speech. This is the case that I cited kind of at the beginning. This is not an ALDF case, but it's very useful, especially because it addresses that reasonable consumer setting. We've got the biggest appellate court in the nation saying reasonable consumers are not going to be misled. They don't think that imitation is an appropriate term because it's not an imitation product. This is important, and the reason I highlight it here is because of next steps with FDA. FDA has indicated after the House Committee on Appropriations said, hey, we're really concerned about the names of these products, and we hear there's lots of consumer confusion. So FDA kind of got, marching orders to create some kind of guidance. They indicated that guidance document would be coming out last month. We haven't seen it yet. FDA or ALDF had submitted several comments, including our most recent round of comments to FDA about this guidance document drafted by your own Michael. Thanks, Michael. Yeah, so happy to share those comments. Good money is that FDA guidance is maybe not going to be a great one, and that sets up anyone who has commented on the request for comments to bring an Administrative Procedure Act challenge if that draft guidance is ignoring, the vast majority of comments that said consumers understand this. We don't need any additional guidance. We don't need any additional hoops for plant-based producers to jump through. This is really, attacking innovation and, more sustainable, healthy products and their ability to compete, in the marketplace on an even keel with other producers. Okay. I think I'm only 2 minutes over. It was a lot of content, so I'll stop sharing. And if you guys want to stick around for questions, I'm happy to answer that. And sorry for speaking really, really quickly.
Thank you so much, Amanda. That was a great presentation. Does anyone have questions? Feel free to just unmute and ask away.